Good day, I'm Celeste de Haas from Remax Midlands, and today of part 1 of our 2-part video, Sectional Title Scheme Management. Subject to local authority town planning regulations, building restrictions and common law, owners of freehold title properties are free to manage their properties as they please. A sectional title owner, however, is governed by a number of additional restraints that set out strict procedures as to how the property has to be managed and who is responsible for such management. As the owner in a sectional title property scheme, you own your section, the flat, the apartment, townhouse or freestanding house, exclusively. You co-own a portion of the common property in undivided shares, generally based on the floor area of your section. Common property is all other properties in the scheme that do not form part of the sections. You may also have rights to one or more of the exclusive use areas, which are part of the common property, that have specifically been set aside for your use, exclusive use. It seems logical that because you own your section exclusively in this area, you are entitled to make all the decisions on your own, and you alone are responsible for maintenance and repairs. Following the same logic, the common property is owned by every owner. Therefore, every owner should be allowed to participate in decisions made regarding its use, and every owner must contribute towards its maintenance and repair. This is where the concept of communal ownership comes into play. In the sectional title concept, owners can make decisions together and are dependent on each other in terms of the expenses of communally owned areas in the scheme. It has also been said many times that co-ownership is the mother of all disputes. For this reason, the legislator has implemented strict rules and procedures to help streamline processes involved in communal decision making and financing sectional title sphere. The key role players in sectional title management are the owners, making up the body corporate, the trustees, who are elected by the members of the body corporate as the managers of the scheme, the chairperson, who is elected by the other trustees, and the managing agent, who may be contracted to help the trustees perform the functions of the body corporate. What laws and rules apply? The Sectional Title Act is the legislation providing for and governing sectional title in South Africa. It deals with scheme management, including the following: the composition of the body corporate and its functions and powers, the trustees and their functions and powers, the rules applicable to the schemes, and the duties of the owners. Every owner, trustee, chairperson, and managing agent should have a copy of the Act and try and familiarize themselves with its management provisions. The prescribed management conduct rules are annexed to the Act and are automatically applicable to the scheme unless they are amended, substituted, added or deleted. Where this is the case, the scheme operates according to its amended rules. The State Agency Affairs Act governs managing agents, and according to its regulations, managing agents are required to be in possession of a valid Fidelity Fund certificates at all times when collecting and receiving levies from sectional title schemes. The National Building Regulations and Standards Act is also relevant to sectional title schemes, as it prescribes that all building plans must be approved by the local council before any building may commence. The town planning scheme regulate, govern and restrict in which an occupier may use the section in a scheme. So let's discuss the role of the body corporate. The body corporate is a legal entity made up of all the owners in the scheme. Membership of the body corporate is compulsory and occurs automatically when a section is transferred into a buyer's name. It continues until that person is no longer the owner of a section in the scheme. The body corporate exists to manage and control the scheme by ensuring that its financial, administrative, and physical needs are attended to. The functions of the body corporate include running the levy fund, operating the scheme bank accounts, ensuring the buildings for full replacement value, maintaining common property, keeping owner records, providing various types of information, ensuring that there's an address where the scheme's correspondence can be received, lodging notification of rule changes with the Registrar of Deeds, and enforcing the scheme's rules. The way in which a body corporate makes decisions is by owner resolution at duly convened meetings. The annual general meeting, called the AGM, is the principal meeting at which the body corporate makes important decisions such as electing trustees, appointing an auditor or an accounting officer, providing the budget for expenditure for the following year, and any other decisions that may be necessary in the inclusions of items of the special business on the agenda. In the time between AGMs, special general meetings of owners may be called by the trustees or by the owners themselves in certain circumstances. These meetings arise if or when business needs to be considered and or decided upon before the next AGM. Instead of calling a special general meeting, owners can also make certain decisions using the round robin process, in which they sign a circulated text setting out the text for the resolution. So there you have it for today's tutorial. Subscribe to our channel to stay tuned for part 2 of our sectional title scheme management video, explaining the roles of the trustees, chairperson, and managing agent. Pop us a mail or a message. Call us. We would love to hear from you. I am Dynamite Haas.